All right, let's jump right in. The entire map for carrying a firearm in America, it's just been completely redrawn. You know how in some places you've been told you need a special reason to carry a gun for self-defense? Well, that entire system is now gone.
To put it as simply as possible, the old system for getting a permit to carry in some of the country's biggest states is now unconstitutional. A single Supreme Court ruling has fundamentally changed the right to bear arms outside the home. The script has been totally flipped.
And look, the scale of this is it's staggering. This is not some minor legal tweak. We are talking about over 100 million Americans living in states like New York, California, and New Jersey, whose super restrictive gun permit laws were pretty much struck down overnight. This was a seismic shift. So what's the case that triggered this earthquake? It's called New York State Rifle and Pistol Association versus Bruen. And I'm not exaggerating when I say it is one of the most significant Second Amendment decisions in over 100 years. This whole thing zeroed in on New York's law, which had been on the books for a century. To get a concealed carry permit there, you had to prove to some government official that you had proper cause. Basically, a special, unique need for self-protection that set you apart from everybody else. The Supreme Court, in a 6-3 decision written by Justice Thomas, said, nope, that's unconstitutional. And this right here, this is the heart of the ruling, just perfectly summed up. The court's message was loud and clear. The Second Amendment itself is the reason. You no longer have to audition for your rights. You don't have to convince a bureaucrat that your life is in just enough danger to be allowed to exercise a right you already possess.
Okay, so this decision forces a huge change in how carry permits are actually handled. We're moving away from that old restrictive system called may issue to what is now the constitutional standard for the whole country, shall issue. Let's break down exactly what that means. So the most important thing to get here is the switch from subjective to objective. In a may issue state, an official had the discretion, the personal power to deny your permit if they just didn't think your reason was good enough. It was a total judgment call. Now, the entire country is shall issue. What that means is if you meet the clear, objective, legal criteria, you pass the background check, you do the required training, you check all the boxes, the state shall issue you a permit. Their personal opinion is completely out of the equation. But here's the part that a lot of people miss, and honestly, it might be the biggest deal of this entire ruling. The impact of Bruen goes way, way beyond just carry permits. It created a completely new legal standard that courts now have to use to judge all gun laws. It's called the historical tradition test. See, before Bruen, courts would often kind of weigh public safety benefits against how much a law burdened Second Amendment rights. Well, that's gone. Now, the only question that matters is this. Does a modern gun law line up with the country's historical tradition of gun regulation from the 1700s and 1800s? So if a state wants to ban a specific type of firearm today, they can't just say it's for public safety. They have to point to a historical twin, a law from way back then that did basically the same thing. If they can't find one, that law is probably unconstitutional. So how does this new test work in a courtroom? Well, it's a two-step process. First, the court asks a simple question. Does the plain text of the Second Amendment, the right to keep and bear arms, even cover the activity we're talking about? For carrying a handgun in public for self-defense, the court said, yes, absolutely. Once that's settled, the second step kicks in, and the burden shifts entirely to the government to prove its regulation is consistent with that historical tradition. It is a much, much higher bar for the government to clear. Okay. That's the legal theory. It's a bit abstract, I know. But what does this actually look like for real people? Let's walk through 3 different scenarios to see the direct impact of this ruling. Okay, first, imagine a small business owner in New York City. She carries large cash deposits to the bank every night. Before this ruling, she could be denied a permit because some official decided that, carrying cash didn't make her a special target. After Bruen, that subjective denial is illegal. If she's a law-abiding citizen who passes all the checks, she gets the permit, period. Or think about this. A woman in California is being threatened by a former partner. She's filed police reports, she's done everything right. But a local sheriff could, in their own judgment, decide the threat wasn't serious enough to justify a permit. Now, her assessment of her own safety is what matters. The state no longer gets to second-guess her need for self-protection. And finally, let's picture someone in New Jersey. They're a law-abiding citizen who simply wants to carry a firearm for general self-defense, just the basic idea of being prepared for the worst. Before Bruen, an application for that reason was an automatic denial. After Bruen, that is the only reason you need.
The right itself is the justification. As you can see from these examples, the legal ground is shifting fast. States that are affected by this ruling are scrambling to pass new laws, and the whole situation is evolving almost daily. Seriously, staying informed right now has never been more critical.
Now, anytime a huge decision like this comes down from the Supreme Court, misinformation just spreads like wildfire. So let's take a minute, let's clear the air, and let's debunk some of the biggest myths about what the Bruen decision actually does, and just as importantly, what it doesn't do. First up, the big one. This idea that the ruling created so-called constitutional carry, or permitless carry, all across the country.
Yeah, that's completely false. The court struck down how certain states issue permits, not if they can require them at all. States can absolutely still have a permitting process. They can still require objective things like background checks, fingerprints, and safety training. The only thing they can't do anymore is subjectively deny law-abiding people who meet those requirements. The second huge myth you hear is that this decision just got rid of all gun-free zones.
This is also false. The Supreme Court was actually really clear that governments can continue to restrict firearms in sensitive places, and they used schools and government buildings as historical examples. Now, what's happening is some states are really testing the limits of that idea, trying to declare huge areas like all public parks, libraries, and the entire public transit system as sensitive. While these new zones are being aggressively challenged in court, you gotta know, they are currently enforceable until a court says otherwise. So, with all that on the table, where does this landmark decision really fit into the bigger picture? And what does it tell us about the future of gun laws in America? Probably the best way to understand Bruen is to see it as the third chapter in a modern trilogy of Second Amendment cases. The story really started in 2008 with the Heller decision, which confirmed an individual's right to have a gun for self-defense inside their home. Then, in 2010, the McDonald case made sure that right applied to all states and cities. And now, in 2022, Bruen basically completes the arc by extending that core right of self-defense outside the home.
So, if you only remember 3 things from all this, make it these 3. 1. Subjective may issue permitting is dead and buried. It is unconstitutional. 2. History is the new standard. Every single gun law, old and new, is going to be judged by this historical test. And 3. The clear trend from the highest court in the land is a powerful expansion of Second Amendment rights. This new historical test has thrown the entire world of gun law into question. Legal challenges against everything from so-called assault weapon bans to magazine capacity limits are all being refought under this brand new standard. And that leads to the big question: what's the next domino to fall? Let me know what you think in the comments. The legal battles are really just getting started, so if you want to stay on top of how it all plays out, make sure you're subscribed. You don't want to miss our next update. Thanks for watching.